And our guest for this hour, joining us, criminal defense attorney Silva Megerdician. And Silva, great to see you. Thank you so much, as always, for joining me here on the program. And it's just so sad to see, if not understandable, both sides well represented in the courtroom. Again, as I mentioned earlier, seem to be on the victim's side, some sense that the other side may have been doing something on social media that they didn't like, and maybe things erupted in the courtroom. Quickly, your thoughts.
Yeah, of course, Michael, and thank you for having me on. It's just, again, in cases like this, there are no winners. It is a young woman who lost her life and a 16-year-old who essentially is losing kids. And we see this far too often. Michael, I do half of my practice is juvenile defense, and there's nothing more emotional than having two sides of a family, one side that lost a loved one, the other one who's going to lose their loved one to life in prison, and in this case, without parole. And I think that's the hardest thing. And social media, I advise all my clients, as well as family members, do not post. All it does is incite, and the court can hold social media content against family members too. Inciting a fight in a courtroom can bring up misdemeanor, even felony charges. So, that's why we have armed deputies in courtrooms. It shouldn't happen, but it happens too often. It's just, again, essentially lost lives in this tragic case that was so unnecessary.
It's such an incredible roller coaster of emotions that I've had throughout this. You hear from the victim's family, then you hear from the defendant's family talking about a young man who seemed like he had a side to him that was very loving, very caring, and on the right track. Then you hear the prosecutor talk about all these other things, trouble while he's in prison, some other things that happened after the shooting, the fact that he was part of the antagonists in this whole thing going down. It's hard to reconcile the two, and this is something that the judge is ultimately going to have to reconcile.
Yeah, Michael, look, I'm a criminal defense attorney, and I don't believe in lost causes. And the prosecution's argument hinges on the fact that this young man is never going to change, that he is a lost cause. And it really depends in these cases on the judge's outlook on rehabilitation. Do they believe that it's possible that a 16-year-old, after 20 years, after 30 years, when their frontal cortex, when their brain has fully formed, can they change? And I think the sad part is it becomes what the judge's opinion is as to rehabilitation. And the defense is always going to want to cite reports that show reoffending after a young person is committed into the state prison sentence is very low. So it's just a tragic case. And I'm hoping, again, that we still keep rehabilitation alive, especially for people under the age of 18, because I've seen it in my practice. They do change.
Yeah, one has to believe in that, I think, in order to sort of get by. And throwing a young kid in jail without hope of something in the future, I think, is also very, very cruel and maybe even unusual, as the Constitution might define it. But again, that's an argument for another day. Silva, stand by. We're going to take a break, folks. I want to let you know, if you notice, the verdict clock has stopped in Hicks. 2 hours and 57 minutes. There is a verdict. So we're going to bring that to you when we come back. Keep it here on Court TV, your front row seat to justice. All right, folks, we have breaking news out of Ohio. After just under 3 hours of deliberations, the jury has reached a verdict in the drowned wife murder trial of Paul Hicks. Now, he faces life in prison if convicted of killing his estranged wife, Regina, whose body was found 4 days later inside her car, which was submerged in a pond almost 25 years ago. I think the jury is in. I want to take you into that courtroom now.
Four counts?
Yes.
And have they each signed each of those verdicts, all 12 members?
Yes.
And have you filled in guilty or not guilty in each of the verdict forms?
I believe so, yes.
All right, I'm going to ask if you will turn those over to the bailiff. Give me a moment to review them. Very good. At this time, then, the court would read the verdict forms for purposes of the record. In the state of Ohio versus Paul Daniel Hicks, 2025-0284, on the indictment for count 1, the murder, the jury finds the defendant guilty of murder of an unclassified felony. It's dated December 19th, 2025, and they appear to be signed by all 12 members of the jury. Would you like the jury polled on this?
Your Honor, I will wait for the rest of the members to weigh.
All right, very good. As far as count 2 then, the jury finds the defendant, Paul Daniel Hicks, guilty of murder and unclassified felony, which was the proximate result of the defendant committing kidnapping, which is a felony of the first degree. Again, that's dated December 19th, 2025, and appears to be signed by all 12 members of the jury. As far as count 3, on the charge of murder, the jury finds the defendant, Paul Daniel Hicks, guilty of murder and unclassified felony, which was the proximate result of the defendant committing felonious assault, which is a felony of the second degree. That's dated December 19th, 2025, and is signed by all 12 members of the jury. And finally, on count 4, kidnapping, the jury finds the defendant, Paul Daniel Hicks, guilty of kidnapping under the first degree. That's also dated December 19th, 2025, and signed by all 12 members of the jury. At this time, then, will the jury poll?
Yes, Your Honor.
Then, at this point, I don't know if I have my jury sheet. All right, we'll go by front row first and then work to the back. So I'm going to ask first, and I gave my sheet away with your names, and I have not memorized it. Juror number 1, is that your true and correct verdict?
It is.
And juror number 2?
It is.
And juror number 3?
Yes.
And juror number 4?
Yes.
Juror number 5?
Yes.
Juror number 6?
Yes.
Juror number 7? In the back, juror number 8? Juror number 9?
Yes.
Juror number 10?
Yes.
Juror number 11?
Yes.
And juror number 12.
Yes.
All right, so all 12 members of the jury have confirmed that those are their findings and verdicts as presented to the court. I do want to thank you all for a long 2 weeks of service. Certainly you gave this matter a lot of consideration, and I'm going to ask if any of you have the ability to stick around for a short period of time. Traditionally, it's an opportunity for the court to have an opportunity to speak with you. We'd like to find out what your experiences were like here, what we might be able to do better or different as we go forward with future juries. Sometimes the attorneys would also like the opportunity to speak with you. You don't have to stick around. You've given us an awful lot of your time. You can take off whenever you would like, but if you can't stick around for a few moments, I would appreciate it. As far as the attorneys, I'm going to speak with you first, and then if you want to have a chance to speak with the attorneys, we can let them know. Is there anything further than from the, well, I should say, we did discuss the potential for a sentencing date. The sentencing date would be set for January 9th, 2026 at 1 o'clock. Anything further from the parties before we let the jury retire?
No, Your Honor. No, Your Honor.
All right, very good. Thank you again, folks. I'll be back with you shortly.
There's one thing.
We'll take a moment. All right. Outside the presence of the jury, anything in front of the record?
Yes, Your Honor. Judge, last April you set a $2 million bond on the defendant. He hasn't been able to make it. Now that he's been found guilty of murder plus kidnapping, he's facing a sentence in prison of life with possibly parole. After 26 years, we would ask that the bond be revoked.
All right. And defense?
Objection, Your Honor. Noted for the record.
All right. The court will revoke bond given the sentencing options that are available to the court. All right, very good. I'm going to take a moment. If they want to speak with attorneys, I'll come back and let you know.
Thank you, Judge.
Oh, all right. Just one.
Sorry.
The court reporter has reminded me that the parties have agreed they would be willing to substitute photos for purposes of the record as to the physical exhibit.
All right, so justice delayed, not justice denied for the family and supporters of Regina Hicks, the victim in this case. Again, you heard the jury. They found him guilty on all counts, including murder, 2 counts of felony murder that included kidnapping, as well as felonious assault, as well as a 4th count of kidnapping. And as you could see, it was an incredible shot. In one instance, we saw the defendant throw his head back as he heard the guilty verdict. Meanwhile, supporters, obviously supporters of Regina Hicks in the gallery, throwing their hands up, fist pumping, happy after 25 or so years, finally getting justice. Let's bring in our guest still with us, criminal defense attorney Silva Megadici. Silva, love to get your reaction to this verdict. Only about 3 hours. I think it was 2 hours and 57 minutes or so. Always a bad sign for the defendant. Your thoughts?
Yeah, it's so true. You know, Michael, I was watching your coverage yesterday, which was fantastic. And what was interesting was there was the witness of 20 some odd years ago that was granted full immunity for his testimony. Unfortunately, we couldn't see his testimony because he did not want to be televised, but he was granted full immunity. And I had said that what's interesting about that is it's up to the jury to question his character and whether he's credible. And I think that testimony is what convicted this defendant. There's actually another piece that convicted the defendant too. And that is when the defendant spoke to police, he had stated that, oh, you know, my wife was an alcoholic and a drug user, something to that extent, I'm paraphrasing. And the only thing that was found in her blood, I think it was Tylenol or some kind of pain reliever over the counter. I think there were little bits of evidence that the jury probably really latched onto. And even though I thought there was reasonable doubt here, I could easily see why a jury convicted. And I think the prosecution's closing argument was spot on when they said there's no other suspect here than him. And that really hangs on the jurors' minds. If not this defendant, then whom? Yeah. And I think that was really powerful from the prosecution's end.
Yeah.
Verdict makes sense to me.
Oh, absolutely. According to the defense, it wasn't another who, it was that she committed suicide. And there really was no evidence that she was in that kind of state of mind. So it was a tough hill to climb regardless. But the way I saw this case, I kind of disagree with you. I thought Steve Gates, he was the friend. His testimony obviously was important, but I think more so, it was the removal of the impediment. Because when I look at the evidence that they had in addition to his testimony, there was plenty to convict the guy. I think what kept them from prosecuting him was they had the friend, Steve Gates, saying, he was with me and we weren't there. And so they didn't want to try him. I think either they were being responsible or they didn't want to go into court and have this guy come in and say, hey, he wasn't even there. Why are we even here? I think once that impediment was removed, then they just went full force with the evidence. So I'm not even sure how important Steve Gates was.
You know, Michael, look, we've both been in this business so long, and in trials, what I notice afterwards, which I love when the judges allow us as defense attorneys to go talk to jurors, they really do hinge on those witnesses that were there at the time and are testifying, you know, for the first time with this protection, because they don't really have a dog in the fight per se, but there is that looming immunity. And yes, there was evidence, but it's really hard to get convictions when cases are over 2 decades old. But your point is valid, Michael. What's amazing about this, about all juries, we really don't know what they hinge on, but again, they grasped onto something that gave them a really quick verdict. And honestly, I could see why. But the defense attorney in me, Michael, is always going to say, look, I think there were a lot of holes in the evidence where a discerning juror could have said there's reasonable doubt here. But again, I completely agree with and understand the jury's verdict. I just wish I was there in person. It would have been really interesting to see this testimony of Mr. Gates.
Yeah, I would have to agree. At one point, he did get emotional. I think that probably helped it all if they did believe his testimony. Yes. So I think there's that as well. All right, Silva, stand by. We're going to take a break here, folks. Coming up, we're going to take you back to Wisconsin for the sentencing of Parise Larry. And as we head to a break, I also have a quick programming note for you. The Reiner Family Murders, a Court TV special, airs tonight at 8 p.m. Eastern. Court TV lead anchor Vinnie Politan takes us on a deep dive inside that investigation, while field reporter Cody Thomas joins live from the scene in Los Angeles. It's a special you don't want to miss, so keep it here on Court TV, a front row seat to justice.
Bob Reiner and his wife. Double homicide.
Their own son charged with their murders.
We will commit ourselves to bringing their murderer to justice.
The Reiner Family Murders, a Court TV special. Tonight, 8/7 Central on Court TV.
Do you think you deserve to die?
My goal is to make sure that you remember me for the rest of your life.
Oh my God.
Interview with a Killer. Marathon starting Christmas night, 8/7 Central. Only on Court TV.
All right, now back to sentencing for convicted killer Paris Larry. A jury found the 16-year-old guilty of first-degree intentional homicide in the shooting death of Tatiana Zek. Zek was taking out the trash at her apartment complex when she was shot and killed. Investigators say Larry and another teen actually intended to shoot someone else when Zek was killed. Larry faces life in prison, so let's go back inside that courtroom now. The judge is beginning to address the court after that heated exchange in the gallery.
On the record. To say that I am frustrated and disappointed is an understatement. I started this hearing this morning with the warning about what I had hoped would not happen today, and it's exactly what happened. This courtroom should be able to be a safe space for justice to be accomplished for everyone involved. Now, you should be aware that people who were involved in the circumstances that took place before we broke for a significant period of time, there have been some arrests. There may be other people facing charges. From this courtroom. I had granted leeway this morning, knowing it's very cold outside. Everyone wearing a hat, take it off. Hats off. I'll wait till more people. I don't want this to fall on deaf ears with half the people missing. Hats need to be removed. That means the red hat. The red hat comes off. As I was saying, I was expressing my extreme displeasure with everything that transpired a few hours ago. I'm not going to play these games. I'm not going to have anyone's safety in this courtroom jeopardized. Do you think Tatiana, any of the other victims, would have appreciated anyone's behavior? Do you think Paris appreciates anyone's behavior in this courtroom? I guarantee not. It is absolutely ridiculous. This is a court of law. I gave you a warning this morning. So any good graces that individuals in this courtroom have been provided, you've lost those. So as I was saying, if there are any words that are mumbled, comments to the other side of the aisle that I think are inappropriate, if I hear anything, you're out. You're not going to be disrupting these proceedings. If there are movements that give me any sort of concern, you will be escorted from this courtroom. As I said, I gave the leeway this morning to have hats on given the weather. Hats need to be off. I already warned people about cell phones. I'm going to make that warning again. Cell phones need to be off, not silenced, not on vibrate, put away. I don't want to see it. If anyone in this courtroom, we've got obviously a lot more presence of law enforcement now. If anyone sees a cell phone, you can have that person escorted out of the courtroom. We're not going to be playing these games, as I said. If there are more problems in this courtroom, you may also face findings of contempt from the court. These are serious circumstances before the court. For Mr. Larry, for the victims who are involved, the fact that the individuals who are sitting in the gallery who should be here supporting their loved ones, whichever side of the aisle you may be seated on, have chosen to put their own selfish behavior and their inability to control their own actions ahead of that support is absolutely ridiculous. If there is anyone who feels unsafe leaving here today and would like to have an escort to your vehicle as you're leaving, please reach out to one of the law enforcement officers that are here. They will provide that escort. As I said, from the beginning this morning, I want to make sure that we move forward in a respectful and safe manner. Everyone should be able to expect that here in a courtroom, and you should be able to expect that as you leave. But I will be watching, my staff will be watching, the law enforcement officers that are now circling the courtroom will be watching. If any of the orders that the court just gave are violated, they will be escorting you out of the courtroom. Now, for the record, as the record probably got cut off as we were forced to end these proceedings very abruptly due to what looked like to be a brawl starting in the back of the courtroom. We were discussing, Attorney Tony had the floor. He was giving the state's sentencing argument. We haven't gotten to a recommendation yet, but that's where we left off. It's my understanding after things continued to occur in this courtroom, it extended outside the doors of this courtroom. It extended out to the parking lot. All of that needs to stop. Attorney Tony, is there anything from the state before we pick back up where we left off that you wish to add on the record?
I think the court made a general record of what occurred. I don't know that we need to get into more specific. Well, I think just for the record, as the state was making its argument, there were, at least from I'm sitting facing the courtroom to my left, I could hear some murmurs coming from the left side of the room. I could then hear things coming from the right side of the room, and then both sides of the room seemed to converge as the kind of verbal altercation started that appeared to get physical. And then I think the court and parties began leaving the room. The defendant was escorted out, and more law enforcement arrived in, making it impossible for the proceedings to continue.
All right, that's fair. And it's my understanding matters did get physical with a number of individuals. Attorney Jensen, anything or Attorney Mogren, anything from the defense?
Well, over the break, Mr. Mogren and I thought about it and discussed it. We considered filing a motion to adjourn the sentencing on the grounds that it was a very upsetting circumstance this morning, and we decided not to do that because it seems like Your Honor is completely calm about it and not upset in the sense that it would be held against Mr. Larry. We also considered moving to seal the courtroom and seal these proceedings and have everybody in the audience removed because the constitutional right to a public trial belongs to Mr. Larry, and I want him to be safe, and I don't want the behavior of people in the audience unduly influencing the court. But we decided against that. We're satisfied that the additional security makes that safe. So we decided not to make that motion.
All right. Thank you, Attorney Jensen. And to your point, I think that echoes some of the statements that the court was making, because Mr. Larry is here facing some very significant penalties. There is nothing that should increase unnecessarily the stress that he's already enduring. The victims that are here are experiencing, perhaps reliving some of the circumstances of the loved ones they've lost or that were injured. They should not unnecessarily have to have the added stress of the events that have taken place this morning, which is why I started this morning with the words that I did. Clearly they weren't heated. Nothing that happened here is the fault of Mr. Larry. Obviously, his choices may be why he's in that seat, but there was no instigation on his part, so I will make that noted for the record. I did not see any turning around or any engaging from his part in what transpired earlier. So nothing that has transpired is going to impact the court in its decision as it relates to the sentencing that we are here on. What it may.
All right, we'll have more of that sentencing in just a moment. I'll quickly bring back in our guest, criminal defense attorney Silva Megadichian, and Silva, the judge, laying down the law. But I really like what the defense did, making sure to get on the record that we were happy. We're not going to go forth with some of these motions because it looks like the judge understood, is in control, is not going to hold it against the defendant, and also looking out for the safety of the defendant as well.
Absolutely, Michael. It's not just about the prosecution and the victim's family. It's just about everyone's well-being. And also, you don't want to be unduly prejudicial to the defendant. You don't want the judge to hold anything against the defendant. And the fact that the defense put that on the record saves it for appeal as well, and just saves their client's best interest. And it is true, considering, you know, the prosecution said this kid was a complete lost cause and a danger to society. He could have gotten involved and he didn't. He sat down. He actually controlled himself. That's actually a good thing, but, you know, it's up to the judge to take that into account or not. She did mention it, that she was proud of him for not doing anything, but I think the defense really did. They protected their record. They said they were satisfied and really spelled it out. Some people would think it would be laborious, but they did the right thing by spelling it out and making sure that not only did the judge rule that way, but believes that way too. So it's really well done.
All right, Silva, this defendant facing life in prison, where do you think the judge might land?
Oh, Michael, look, you know, again, as I said, I am a juvenile defense attorney. I wholeheartedly believe in rehabilitation. I believe that people change, and I've seen people change after doing 10, 20, 30 years in custody. I'm representing someone right now after 45 years who is not the same person he was when he was 16. She's going to go life without parole, unfortunately.
Oh, gosh. All right. Silva Megadichian, thank you so much for joining me this afternoon. Always a real pleasure to have you on the show. Have a great weekend. Folks, stick around because we have more of that sentencing hearing for Paris Larry Jr. right after the break, so keep it here on your front row seat to justice.